It's SB822. And SB822 allows for a supervisor, for example, at a hospital setting, in a community mental health setting, provide feedback and evaluation for students who are becoming psychologists and be immune from liability. And this immunity is it's important is, I'm not sure how many of you have had this experience of late, those of you who do supervision, but it's been my experience in the past, particularly 5 to 7 years, that students have had an increasingly, how shall I say this, intense sense of entitlement. And there's at least a portion of supervisees who feel that they are owed the hours that they are trying to earn rather than earn them. And so the California Psych Association, about a year ago, through one of the representatives, introduced SB2, and it was just signed into law. There's been an increasing sense, I think, of vulnerability that supervisors have experienced, and it's been in general throughout the community. The California Psych Association went ahead and worked with and managed to get a law passed very recently that there is at least qualified immunity for psychologists as well as for a number of other folks who are involved in the healing arts. It's not just restricted to hospitals. And I can go into the detail, but it basically if we're doing evaluation. Now, interestingly enough, this kind of immunity is different than the immunity you heard me talk about in the section on child abuse and the immunity for child abuse reporting. You'll probably recall that the child abuse reporting immunities are very, very strong. Those are actually designated absolute immunities. So you'll remember that in one of the slides and some of the provided in the lecture, I mentioned that there was the McMartin case and other cases where the appellate courts basically said it didn't matter what the intent of the mental health professional was in making a child abuse report. Mental health professionals are immune from liability, period. Now, that's not the case with supervisory immunity. It's a qualified immunity. We may be put in the position of having to demonstrate our intent. That means, for example, that we have to show that, I will get to the child abuse report shortly, but that we'll have to show that we were actually evaluating someone for their suitability for the profession, for their competency, that sort of thing, okay? And so we are protected, but in not as solid a way as isn't there a current where a psychologist is in legal trouble for having made a child abuse report? What's that old saying by Mark Twain? I think it was, "The rumors of my death have been greatly exaggerated." In this case, the rumors are a little bit exaggerated. My reading of that particular case in New Hampshire is that it wasn't simply by virtue of doing the child abuse report that there's a psychologist in legal trouble. However, for our purposes, the case and situation is largely irrelevant because immunities from liability for child abuse reporting flow by state. In other words, that has to do in part with the child abuse reporting laws in New Hampshire. We are not subject to those laws. We are subject to child abuse reporting law immunity. Yeah. That means that our does the new law only apply to psychologists? What about MFTs and LCSWs? It does not currently apply to MFTs and LCSWs. All right. So my sense is that it needs to be one of the things that I haven't talked about, and I did mention that the sense of kind of narcissism among students and also increased vulnerability for mental health professionals, that the courts tend to be very, very deferential about our judgments vis-a-vis students. In other words, student evaluation in general, if we follow our own procedures, then we are and we are careful about them. So for example, in doing an assessment of a student who is in a practicum, if we follow the usual procedures that are required by the school that we're doing the assessment for, then courts tend to be pretty protective of us. That doesn't mean that we may not feel vulnerable, but courts in general are going to give a very significant amount of weight of supervisors and the judgments of schools. They have said over and over again that they're not going to substitute the judgment of a court for the judgment of professors or supervisors. So the extra protection. Look at education law and supervisory law in general. We are given a fair amount of weight in our judgment. Does the new law apply to all student evaluations, not just supervision for the purposes of getting hours for licensure? And actually, the way it is couched is essentially says, and if you'll hold on a second, that when a hospital staff or professional staff, people who are evaluating students, communicate information to a facility or a school. So it's not solely focused on licensure hours. It is assessment of students in general, of determining, among other things, their fitness to be mental health professionals. In fact, the language says